Hello and welcome to the BDO Talking Trusts 2021 series. This is episode 3 of our 4-part series for this year, which aims to bring clarity to the purpose and application of trusts in wealth management. In this series, we host experts in tax structuring, trust law, and family business governance who will share practical advice and guidance on how the trust and the family can work together for a family legacy and long-term wealth creation. I'm Ricardo Teixeira, Chief Operating Officer at BDO Wealth Advisors, and I'll be your host for the Talking Trust series. Thank you for joining the conversation. Previously on Talking Trusts, we focused on helping you navigate your duties and responsibilities of being a trustee. This year, we extend the conversation and aim to bring clarity to the opportunities and solutions on how to get the trust working for you and your family's long-term wealth creation. Today's webinar will be recorded and added to our website and BDO YouTube channel, together with all previous episodes in the series. We have set aside time for an interactive Q&A session following the talk. So if you have any questions or if there are areas that you would like discussed further, please line them up by using the Q&A function. You'll find that in the top right-hand corner of your screen. Just look for the speech boxes with a question mark. BDO has been providing professional audit, advisory and tax services to families and businesses for over 60 years in South Africa. And to be candid, we've seen a lot of trustees and families struggle with optimizing the family trust for wealth creation. Trusts are, however, wonderful vehicles. By having the right solutions and processes in place, the trust can be extremely beneficial to a family's wealth creation and protection. A trust is a unique structure though, and certainly more complicated than managing a company. There are many nuances to maintaining the validity of a trust, and as a result, any shortcoming in managing the trust, no matter how insignificant it may appear at face value, may have a devastating consequence on the original purpose and intent in establishing the trust. Our objective in hosting the series is to share practical knowledge and experience of the best practices for effective governance and administration of a trust. Marrying family governance with a trust deed. Today, we continue the conversation we started in episode 2, where we explored the importance of family governance before structuring the trust deed. Today's episode focuses on the trust deed and the aspects that need to be considered in keeping the trust deed relevant. Our guest speakers will share their recommendations in drafting and maintaining the trust deed so that the deed actually aligns to the family vision and governance structures. There is no template for a trust deed. All trusts are unique and need to be tailored to the family's specific circumstances. This principle is often glossed over in the rush to set up a trust. And the trust deed revisions are very seldom considered during the lifetime of a trust. Our guest speaker is well qualified to talk about trusts and share her experience in maintaining the trust deed for your family trust. You met her in episode 2. She's a well-known media personality and published author in the field of trusts. She's a chartered accountant with a master's degree in local and international tax. And she's also a registered fiduciary practitioner of South Africa, a master tax practitioner, and a trust and estate practitioner. Please welcome back Thea van der Spy.
Thanks for inviting me back to the conversation, Ricardo. Today we're talking about a very interesting topic and something that I'm very passionate about. And I want to say 1,000 times during this conversation that there is no such thing as a vanilla trust deed. There's no such thing as a vanilla clause in a trust deed, and that people should really apply their minds. I think too often we experience how intergenerational wealth is broken down when generations are inheriting large sums of wealth if they are not financially experienced and financially educated in terms of the accumulation of wealth. So I just want to recap on Trevor's discussion last week, just to bring some context. So to focus on the 4 key practices that lead to effective intergenerational governance. So very important throughout the theme, and you would also see through my presentation, is the whole notion of communication, how very important it is to involve family members and to make sure you communicate to them in the correct forum. and to maybe look at a family council, especially for larger families with businesses, where businesses become part of the family, and we will actually look at where the trust fit into that whole structure. And then there was a focus on the role and the stewardship of boards of directors. I think equally so for boards of trustees, and I think it's very important to understand how the trustees fit in and where the board of directors fit into a structure, and what each one of those roles actually entail, and what powers each one of those have, especially when a trust owns a company and you may end up with a board of trustees as well as a board of directors who may be or may not be the same people. Then around family mission statements and constitutions, I think there one can become really practical and very specific in terms of what is important in your family, to actually create a set of values for the family and to actually document it around how do we treat in-laws, how do we treat, how do we go about potential divorces coming up? How do we treat things like recreational assets? So typical things that family members have to share. So I think it's very important for the whole family to have a common understanding. And then certainly a trust is not sitting somewhere on the side here and is not, very much part and parcel of such a structure and the execution thereof. And then very importantly is to actually develop the next generation of leaders, those people who actually have to take the reins. We're talking about financial literacy, we are talking about management skills, we are talking about leadership skills. All those we actually have to consider when we actually set up our trust, and when we actually envisage, best we can do probably 2-3 generations down the line. So very important to actually put people in boxes and actually, start developing those people. Sorry, I was on mute all the time. So yeah, we have families sitting in different countries. We have trustees sitting in different countries. We have beneficiaries sitting in different countries. And that has got a material impact on how we actually set up the trust, how we manage the trust, and even things such as taxation we have to consider. So very, very important that we actually experience here that we have to tailor the trust deed around and revise the trust deed as family circumstances change, as people move overseas, and we have beneficiaries and trustees sitting all over the world. Commission, next slide. So I think a good starting point is just to recap, and we spoke about it last year in the Talking Trust series. What exactly is the legal position of a trust? I think that's where a lot of things go wrong. A trust is very different to a will. A lot of people think a trust is similar to a will. You have it drafted. It's not even tailored. It's just some other vanilla document, standard document that your lawyer or accountant has taken. That's drawn up and that goes into some other bottom drawer, and it's forgotten about. It is actually something that you have to actively manage. And I think Ricardo would touch on that next session. And we actually looked at it in detail in last year's session. So if you want to have a look at those recordings. The trust is very unique. It's not the same as a company. I think a lot of people are trying to put it in a box of a company. As far as the reporting is concerned, as far as the management is concerned, you will see later that a trust is run by resolution. It's very different to a company. So don't, when you think about a trust and when you think about putting different people in different boxes in a trust, do not think it's similar to a company in terms of how it's operated, in terms of how we actually report on it. A trust is not a legal entity, and a lot of people, struggling with this concept. It's basically an accumulation of assets. So the courts had a lot of viewpoints, different views in terms of what is a trust. Why is it so different? And the best I could come up with, it is similar to a contract. So it's a contract between two parties for the benefit of a third party. So when we look at a trust, inter vivos trust, typically trust that we create during our lifetimes, we have to take all important considerations that's important for the creation of a valid contract into account, because we are now sticking with the notion of a trust is a contract. And a lot of people don't agree with it, I think, but I think that's kind of the bit that the courts could come up with. Because a trust is a contract, you actually have to follow its instructions. Somebody asked me the other day, is a trust deed just something that gives guidance to trustees? And I almost fell off my chair. A trust deed is not something that gives guidance, it's instructions. It tells you what you can do, what you can't do, what you should do, and what you should not do. And you know, often people want to do things in a trust that they're not even empowered to do. If the trustee doesn't allow you to incur debt, then you cannot do it. So the trustees cannot have a wide power. So the founder, when you have to set up your trust, need to be very specific, you know, what objective you're trying to achieve, and make sure your instructions that you actually have in your trust deed should certainly not be some other off-the-shelf vanilla document. It has to be tailored around your personal circumstances and about your personal objective. The trustees are the custodians of the trust assets as the joint owners. And this is also something else, and especially when we look at how people kind of maneuver clauses in the trust deed to just give somebody a little bit of a better say or a stronger vote. You know, the courts have had a lot, of consideration around, you know, what should trustees do, the whole abuse of a majority decision that we'll have a look at a little bit later. You know, you must understand that the trustees that you appoint are the joint owners of those assets in their capacity as trustees, and it requires their joint action. I said before, a trust is run by resolution. Basically, it means everything that you want to do in a trust requires the trustees' consent in a written format, such as a resolution. Very important that you can't just go off, do your things, and even allowing the trustee to ratify transactions later. It's very important that before you do something, that it's in terms of the trustee, and that you actually have got the trustees to agree to it. Document retention, very important. You can't have anything in your trustee that gives you any more favorable terms. In terms of the Trust Property Control Act, you have to keep the trust documents, all trust documents, for 5 years after the termination of the trust. So it is an owner's obligation, and nothing in the trust deed can actually take that away. A trust deed, when you look at it, is a constitutive charter of the trust. As I said before, it tells you what you can do, what you can't do, and you have to keep it current as, you know, things change. You know, family circumstances change, legislation change. And it's very important to actually make sure, and you can update the trust deed. You know, a lot of people think that you cannot update the trust deed. So when we look at trust in South Africa, you might have heard me speaking earlier, talking about trusts, that only 90% of trusts actually don't exist in South Africa. And that is pure bad drafting. So it doesn't help you to structure a trust to accumulate all your wealth in the trust, but basically the trust does not exist. So we have to stick to the fundamentals of what the trust has to have as a minimum to be a trust. Otherwise, it may be something else. And the court case of Estate Richards versus Nichols looked at those. So the founder must have an intention to create a trust. So we see so many times in the trust deed, again, you sneak in those clauses that just gives you a little bit of protection, a little bit of a way out, a little bit of control. So if those clauses doesn't demonstrate your preparatory intention to create a trust, it's probably not going to be a trust. And you have to transfer control. And again, a lot of trusts have actually clauses that try and retain some control for the founder. The founder must express their intention in the creation of the trust in such a way to create an obligation. They have to hand over the assets that they actually going to donate to the trust as a start, and then they can't kind of claw back that control once more assets are accumulated in the trust. The trust property must be clearly defined in the trust deed. That initial donation must be very clearly defined. When we look at the powers in terms of what trustees can and what they can't acquire, we need to be very specific, what the trust can actually acquire. The beneficiaries must be very clearly identified. Here we see a lot of the trust falling completely flat, because in the old days, again, with their control from the founders, I'm not so certain who I want to make beneficiaries. So I'm going to just keep this little bit of a opening and say the trustees can appoint whoever they want as beneficiaries in the future. We see a lot of those clauses in the old trust deed. If your trust deed has that clause, it means your trust does not exist. Because the Richards versus Nicol case said beneficiaries have to be clearly identified. It either has to say person A with identity number so and so, or it has to say a class of persons, and it must be sufficiently described so you could clearly say, yes, this person actually meets the requirements of this class of a person. So you cannot leave it open-ended. Trustees cannot have a wide power to actually appoint whoever they want. So that's probably one of the big things where you can go and have a look in terms of the trustee to see if there are potential issues. The trust object must be lawful and not the purpose. I'm not going to go too much of this, but I mean, if I create a trust and it's an unlawful purpose, I'm trying to bypass somebody or do something illegally, you know, I'm not going to say it in the trust deed, right? So that's not what this case was about. It says it's a trust object, and the trust object is normally the benefit of the beneficiaries. So very important that links back to what we just spoke about in terms of beneficiaries that we haven't clearly defined. The property must be transferred to the trustees. As I said earlier, the trustees own them jointly in their capacity as trustees. So it's joint ownership and therefore joint control. So I think that's also something very important. The next slide. So when we look at the fundamentals of a trust, it's important to understand the different roles that people fulfill in the trust. So when you put people in those boxes, you don't make mistakes. And a lot of the older trusts, we see that the founder is separate from the trustees and the beneficiaries. They typically said, you, the founder, cannot be the trustee and the beneficiary. The issue is, if you, the founder, and you're going to start accumulating kind of the wealth that was going to fall into your estate into a trust, and you may rely on it in future to actually get some benefit from it. If you're not a beneficiary, you have an issue. So beneficiaries enjoy the assets of the trust. So only beneficiaries can enjoy assets of the trust. So if you're not a defined beneficiary, then there is no way for you to actually benefit from the trust. Very difficult when we actually look at amendment, when people haven't been added as beneficiaries in the past, and now all of a sudden they want, you know, to benefit from the trust. Now I want to do an amendment. Be very careful. There are certain legislation issues, especially as far as transfer duty is concerned, when you know, we change typically the trustees and the beneficiaries, and it's basically like we're selling the trust if there's property inside it. So be very mindful when you change beneficiaries now. On the trustee side, they are the decision makers. They own the properties on behalf of the beneficiaries, and they control it. So if you are not a trustee, you don't have any say in the trust as far as decisions are concerned. So very careful when you're going to look at it later in terms of who you should consider being trustees and who should probably exclude as being a trustee. Okay, next slide. Right, so I think one thing is certain, there is going to be generational wealth transfer, whether we like it or not. And I said 2 weeks ago that in the US alone, they're talking about a 30 trillion US dollar that is going to move in the next 2 decades, you know, typically from the baby boomers, X generation into the newer generations. So when we do planning around generational wealth transfer, I think it's very important to understand the personalities, and we see it so often. If I just look at the first 2 columns, the baby boomers and the Generation X's are clashing, because the baby boomers, they are the workaholics, they're very good team players, they need structure, they're very resistant to change. I think we see that a lot in our grandfathers. And so when we look at the weaknesses of the Generation X, you know, they typically, they're very good workers, they're very hard workers, they more to work-life balance, and they also the biggest revenue generators, but they are typically taken over from the baby boomers who don't want to relinquish that control. Remember all those clauses in the trust deeds? So we're seeing a natural conflict there. When you look at the millennials, I think there's an opportunity here, you know, with the newer generation. So if we look at the Generation X, Z and the millennials, you know, the one's weakness is actually complementing the other one. So we've got the idealists and the realists. So it's probably not a bad idea to start combining them when we look at, you know, kind of future trustees who are going to be the decision makers. As far as the millennials are concerned, we've looked, in the last session, that they're probably the biggest spenders. So I think it's probably going to be dangerous to let them loose alone. And this is obviously generalizing horribly. So I'm sure we have the exceptions. But just looking at the generations, we see a lot of conflict. I'm trying to see, what can we do proactively in a trustee to try and prevent conflict. And, on the expectation side, when the beneficiaries, when somebody's a trustee and a beneficiary, not to look at sucking that trust dry, but to probably capitalize that trust and, rather accumulate more wealth. So I think the balance in a board of trustees is very important. So to only have the baby boomers there and not let your children in, and only when you pass away, then they have to take over, material wealth. I think, it may pose problems. So I think it's important to understand the personality types and see what we can do in a trustee to kind of prevent these potential conflicts and clashes. Next slide. Right, so we said before, it's a reality. We see trust last probably 2 to 3 generations. We can plan for it. I think what's very important is all the boards of trustees in the different generations have to understand that the founder had an objective. And it is very important to honor that objective in the trustees, which, so by the way, can be very specific in terms of if you create a trust and you want it to serve a specific purpose for specific people, you can be very specific in its objective. So that needs to be honored by future generations of trustees. So each family is unique. We have to plan for that. So can we plan for a split up of families, especially remember the more generations that come, the more personalities are involved. So we may get to a point where different families are saying, let's just each go our own way. So the trustee, first of all, has to make provision, therefore, and you need to do it in such a way not to invalidate the trust, because sometimes the trustees say the trustees can create further trusts as they wish on conditions that they like. Those clauses are absolute no-no. So you have to watch out for the clause where we allow future generations to create further trusts. So we need that mechanism. So if we don't have a mechanism, then we can revise the trust deed. Right, next clause, next slide. So just very quickly on the founder, we can see the founder has to divest of the assets. His is no longer his. And often we see in the trust deeds, we just don't achieve that through what we put in the trust deed, and we actually have to get rid of those clauses. Especially if the founder is still alive, we can amend the trust deed, and we just need to make very sure that those controls are taken out. The founder does not really have a role post the formation of a trust, but for potentially being involved in amendment of the trust deed, I think that's important because he created the trust, the termination of the trust. But apart from that, unless he or she is a trustee, he should not, in his role as a founder, really have major rights. Can we look at the next slide? Here's something that sticks its head out. A lot of the old trust deeds have those testamentary reservations in where the founder or the estate planner could basically, upon his death, in his will, decide who's going to get what. Those clauses we have to get rid of. That falls slap bang into section 33D, which says that the day before you die, if you have the power to appropriate or dispose of property, or you can revoke or vary provision of a donation, settlement, or trust for your own benefit or for the benefit of your estate, which is a mouthful. In that event, it automatically falls within section 33D. In other words, if I have a testamentary reservation and I retain myself such a power in the trust deed that I could do it, whether I did it or not, the moment you pick up that trust deed and that testamentary reservation is in there, it's going to be problematic, which means your entire estate will be inflated with the value of the trust fund, which undoes the trust as an estate planning tool. When we look at the second point is when we look at the trust deed amendment clauses, that's typically something that you would want to put in just as a catch-all to say no amendment shall be made of the trust deed that actually facilitates that second point in terms of providing the founder a benefit of the assets for his or her own estate. So we probably just want to put that in the amendment clause or the termination clause as well. Okay, when we look at what's expected of a trustee, we say that's a decision makers. They have to act in good faith. A massive duty on trustees. They have to act with necessary care, diligence, and skill in terms of Trust Property Control Act, which means that if you just blankly appoint people, the mother, the father, the children, every one of those have to understand the role that they fulfill and what is expected of them in terms of the trust deed and in terms of our law. So when you look at it, they have to act with necessary care, diligence, and skill. So you can't claim that you know nothing about trust. You can't claim that people just force you to sign resolutions, which are often here. You have to make sure that you at least study the trust deeds and keep up to date best you can with what is expected of trustees. Next slide. So when we look at specific trust deed terms around trustees, I typically would like to see the following in a trust deed to avoid any abuse and to be very specific, and that should reflect our family's charter or our family's constitution in terms of how do we want to take this wealth going forward. So consider for your family the minimum and maximum number of trustees. No law dictates any number of trustees in terms of a minimum and maximum, so that's a very personal choice. Be mindful of an even number of trustees. If you've got a majority decision, be mindful of an uneven number of trustees, exactly for a majority decision. So that is very important to understand. And as we say, as generations grow, more people get involved. So at least have representation of certain bloodlines in the family. So that is a very personal decision, but this could, prevent certain people from actually getting onto the trust if your number is too low. You also don't want too many trustees in the trust, because how are you going to have a decision made? So who can be trustees, who cannot be trustees? That should link in directly, according to me, in terms of your family charter. Spouses, how far do we take it? Very important to actually consider, do you block somebody in the trust from even becoming a trustee? Because once they're a trustee, they can be part of decisions and they can influence. So very important to either block people in the trustee before it even gets to voting them in. The whole role of the independent trustee, important. How many? We can have one, we can have more than one. Some people say you have to have majority independent trustees. The law says you have to have at least one in a family business trust. The effective dates of appointment of trustees, you can't act as a trustee the moment you sign the forms to go into the master. The master has to physically appoint you in terms of its letters of authority. Your name is not a letter of authority, you cannot sign. So nothing else in the trustee that overrides that, you will act as a trustee with immediate effect. Or when you resign with immediate effect. You have to comply with the law. A trustee cannot override the law, so by the way. So trustee replacement, follow-up trustees, that is so important when you actually plan, for your family. I see the old trustee clauses where the accountant can appoint follow-up trustees. I think it's just so wrong. If you have a strong family charter and the family understands, where we're going with this trust, I think it's very important that, those people should participate in voting trustees on to the trust to actually represent them and to actually decide on trust matters. Trustee removal, not that easy to remove a trustee, so be very mindful of adding in clauses. You can just kick trustees off as you wish. Our constitution protects trustees' rights, so you can't just hire and fire trustees. The courts have been very clear about that. So do not think you're going to appoint somebody and if it doesn't work out, just kind of kick them off in terms of a nice clause that you have in the trust deed. So be mindful of those clauses. You cannot have an alternate trustee. A lot of the old trust deeds show that. An alternate trustee, the master has to appoint a trustee before he or she can act. So the only way you can do it is for that alternate trustee to be physically appointed by the master before he or she can act. Different to a proxy can take your physical decision to a meeting. Say, for example, I just can't attend the meeting. I've deliberated with my co-trustees before. On the day of the meeting, I can't make it, so I will typically send my proxy, and he or she can just convey my vote. Can't deliberate, can't participate. That is the extent of having anybody else rather than a trustee. So any clause in the trust deeds that says anything different to this, or where people want to rely on these clauses, they can't do that. Conflict of interest, you have to anticipate. Conflict of interest, you have to address it in the trust deed. A lot of the trust deeds say how people have to go about. For example, you can be involved in the business if you provide a service to the trust, as long as you disclose it. I think just deal with it. And I think transparency is very important. So I think such a clause would be very important in the trust, especially when we are going to include, family members as follow-up trustees, just to kind of avoid a conflict of interest going forward. And then compensation is typically something that we can deal with in a trustee. Some family members don't want to be involved in the business. They don't want to be directors. They don't want to be trustees. I think it's important then in the trustee to actually make provision for how we go about compensating those trustees who serve on a trust. Just to get back to who manages the trust, there's a lot of clauses that people become really quite creative. The law is very clear. All trustees manage a trust, and they manage trust because there's joint ownership. And then a lot of people would say, what about the majority decision? We can have a look at the next slide. So I just took one case, which makes it really practical, which explains it very well in terms of what the courts mean by joint decision resulting from joint ownership. So the courts don't worry about internally how trustees differ and how they agree and how they go about deciding matters. Internally, they can disagree. The court's got no problem with that. However, once you go out external to the trust, you go out as a unified fund. So there, the trustees cannot differ. You can't then say, oh, but by the way, I didn't agree with that, because the board of trustees agreed. And that is being done through a written resolution signed by all. So here's the catch. If the trustee says you have to have a majority decision, and the majority outvote the minority, and the minority doesn't sign, doesn't mean he can veto the decision. Absolutely not. You are actually obliged to sign that resolution if you are a minority trustee. So what I advise to people, if you completely disagree with the decision being made, I just note that I have not agreed with the decision, but you have to sign. You're obliged to sign. And where the trustees often say a majority trustees form a quorum, the courts say no, because all the trustees have to participate. And I think today, where we are, with connectivity and that, it's very difficult not to be at a trustee meeting. So there's actually no excuse. So it's very easy for people to participate. So a quorum should be all trustees. All trustees have to participate, and that is because of the joint ownership. And a very important point from that case is trust is run by resolution, nothing else. I've said that before. Okay, when we look at meetings, when we look at the trust deed, you need to go into a lot of details in terms of when are meetings to be held. One a year, more than one a year. Be mindful if you put a number in there, then that is a condition. You have to have so many meetings. So careful when SARS knocks on your door and you say you would have, quarterly meetings, and then you haven't even had one meeting. So very important, be practical, but I would say at least once. Who can call the meeting? Any trustee should be able to call a meeting. Have a notice period to avoid abuse. Have an agenda. What is the quorum for meeting? We said all trustees. What if it's not a quorum? So if there's some trustee who's consistently difficult just to block a decision, again, can't be used. So I'll normally have a clause in my trustee to say, if the quorum is everybody, if somebody can't make it for a valid reason, we postpone it with a week or how many days, and then whoever's going to be at that meeting is a quorum then, because I think then you're giving them sufficient chance, because a lot of people just hide away to not be confrontational, but you have to have that meeting. The format of the meetings, very easy to do it digitally these days. I think you can just be very specific in the trustee in terms of what is allowed. Does the chairperson have a casting vote or extra vote? Absolutely not. Take it out. I've seen it in some trustees. And then you've spoken about the decisions for the majority and unanimous votes. So there typically I make provision for some of your more important decisions. You probably want all trustees to agree. The day-to-day stuff, you don't want unanimous decision because you're not going to get anything done in a trust. So on the resolution side, all trustees have to sign, even if majority decision is allowed in the trust deed. And we can also use digital signatures. So you can see you can become very practical in your trust deed in terms of what is allowed, what do you allow, and what you don't allow. The minutes, again, the process around circulation of minutes, approval thereof, because remember, the minutes is the evidence of the meeting. So that's what the courts are going to rely on. So very important to have that circulation, the timing, the final approval, stipulate those in your trust deed, because we see a lot of abuse around finalization of minutes, and then that was even discussed at the meeting. Round robin resolutions, it is allowed as long as all trustees sign, and most trustees stipulate that a round robin resolution is allowed. So you can proactively structure your trust with sufficient guidance and rules, and you can make it very specific. Again, you do not have to just use a vanilla trust deed. You can make it very specific around your own requirements. Next slide. When we look at administration, the powers, if you don't have a power in the trust deed, you can't do it. So again, when we look at family charters, where are we with supporting beneficiaries who may want to start up their own businesses? Are we seeing that, as something that we want to fund out of the trust? We've spoken about the leisure assets in the trust, the powers of use around that. So again, powers are normally very wide, and it's a long list, but some people want to narrow down the powers. You don't want the trust to borrow money if the objective is to really preserve money and not allow loans that expose the trust. So very important to look at the powers of the trustee in terms of what's important to you, what do you want to allow. The bank accounts have to have a bank account. Do you audit the trust or not? We don't have to audit trust, so it's your choice. Compulsory disclosure, and we can look at the next slides. And you can't in the trust deed say the beneficiaries will not receive information, for example. Can we look at the next slide? So yes, this very nice court case, I use it daily, where the court said the trustees are acting in a fiduciary capacity. It's a legal obligation to act in the best interest of somebody whose assets you're looking after. So because of that fiduciary obligation, trustees have to at all times act with utmost good faith. So you can't even in a trust deed, take those obligations out by putting in clauses to say that the trustees won't be held liable for X, Y, Z, and basically undoing what Section 9(1) of the Trust Public Control Act is trying to say, that you have to act with necessary care, diligence, and skill. So we see a lot of those clauses. You're not going to get away, and don't think that clause covers you. So rather get rid of it, because if you don't take it out and we don't have severability clause that actually sever or take out that illegal clause, it may actually invalidate your entire trust deed. So be very careful to put clauses like protection clauses such as that in, where it actually harms you much more than it actually protects you. So you cannot exclude any liability in a trust deed. Right, so when we look at specific clauses again for beneficiaries, we need to be very specific. We said that's one of the fundamental requirements for a trust to exist, is identifiable beneficiaries, not somebody the trustees decide in future. We can have different classes. It makes provision for that. So we can distinguish between income beneficiaries, capital beneficiaries, vested rights. So very nice for changing family circumstance in terms of second wives, second husbands, how we want to go about that. But that could cause a potential conflict between the income beneficiaries, capital beneficiaries. When you invest money, kind of whose hat are you wearing? Because you might have different income outcomes for the income beneficiaries and the capital beneficiaries. If there's no beneficiary, there's no trust. So you have to make sure that if you listed your children, etc., that there's always continuity. When there's no continuity, you have to get to a point where you say, right, if there are no more beneficiaries left, who are the contingent beneficiaries? If you don't have that, the trust literally comes to an end with some dire consequences. Trustees can't uninvest. We have these protection clauses say we may invest, especially for tax purposes, using the conduit principle. But you know what? If something happens to this beneficiary and they've been sequestrated, we can unvest. That is not allowed, and be very mindful. Therefore, when you vest monies, to understand that that vested income or capital gain or asset actually falls into that person's estate, and you can't unvest it, and the trustee can't allow you to unvest. Renunciation of rights, that's a very important thing. If people renounce their rights, which is allowed, then that beneficiary is no longer a beneficiary. That's got massive consequences for testamentary trust. It could basically undo the whole testamentary trust if that was the sole beneficiary, and the person could end up with the assets in his personal name. However, in an inter vivos trust, we can also allow renunciation of rights. Be very careful for cession and selling of rights. People become desperate. Beneficiaries down the line can, get, into real predicaments and may end up, ceding or selling their rights. Have a clause in the trust deed that actually deal with it. Do not allow it unless the trustees approve it, at least, because otherwise you may end up with a situation where somebody's a beneficiary who you never wanted to be a beneficiary in the first place. And remember, beneficiaries have got rights in terms of the Doyle case because you have to disclose information to them. Okay, they have a right to information, so we cannot, again, in the trust deed say, that beneficiaries don't have that right. Okay, next clause. Okay, amendment and termination. If we don't have an amendment clause, if we don't have a termination clause, we have to go to court, which is not a great place to actually amend your trust deed or to terminate the trust when it no longer serves a purpose. So be very careful when you look at your amendment clauses and your termination clauses. First of all, have it. Secondly, be very careful who can approve it. If it's silent, the courts assume the beneficiaries will have to give their consent. If you can't just say just a founder, remember section 33D, and it's got major implications if a founder can on his own vary a trust deed or terminate a trust even. Just a founder and the trustees, maybe, as I say, if you're silent on the beneficiaries, they're going to be expected to have a say. If you are going to for example, say major beneficiaries or a specific class of beneficiaries, that is allowed. So be very careful how you deal with beneficiaries. And you can say beneficiaries' consent will not be required, which is another option, again, around your family. Then the founder, the trustees, and the beneficiaries, that's a yes. And if it's a founder, the trustees, and the major beneficiaries, that could also be a yes. So be very mindful of how you word your clauses. And that brings us to the end of my section in terms of, I hope it was useful, just to demonstrate a couple of the practical things which you need to be mindful of. And you have to study your trust deed. And when you're actually planning generational wealth, I think it is so important to think a little bit ahead in terms of where we're going with the wealth, where we're going with trustees, where we're heading with beneficiaries, kind of these generational differences that we spoke about. And make sure your trust deed is up to date and that is actually legal. Thank you.
Yeah, thank you very much. I think thank you for giving such a succinct overview of a very complicated aspect of trust. I think the basic tenet is that the trust is not a legal entity, but it's ultimately a contract and an accumulation of assets. And so that trust deed is the cornerstone and has to be the cornerstone in administering it. And so I like the points you made around aligning the trust deed with the family structure, with the financial plan. Those are all critical to getting the trust to work for the family. And it's not a template document. It all starts with the family governance structures. So Trevor Dickinson, who you met in episode 2, will close today's conversation by reflecting on the principles of family governance. He's well experienced to talk about facilitating family conversations. He has first-hand experience into the critical issues and challenges associated with working in as well as leading a family-owned business. Trevor completed an undergraduate degree in building sciences, building management, holds an MBA, as well as numerous executive education certificate programs in family business governance. Please welcome back Trevor Dickinson.
Good morning, everybody. For those of you that attended the session 2 weeks ago, you may recollect this slide that indicated that the family governance structure. And I think for individuals for families that haven't embarked on family governance or business governance can feel like a very overwhelming concept. to put into place. And I'm not going to go into all the detail, because I'm on the next slide is really just an overview which encapsulates what family business governance does for a well-structured family business. The top section of the slide just deals with from top to bottom, dealing with the family, ownership, and business matters. I'm going to, on the next slide, please, Ricardo. In essence, family business governance deals with the two constituents, which is the family and the business. And it really is, it's a communication forum. And if a family could just get to understand the fundamental of being able to have a communication structure which enables there to be communication between the family and the business, is in essence what family business governance does. From the family side, it provides a forum for routine and to discuss routine and family business matters. It gives transparency into the business and its operations, performance, and strategy. It can communicate on key issues, and there'll also be the time to be able to discuss aspects of philanthropy and even things like holidays, planning holidays, preparation of policies, etc., that are relevant to the family. Then on the business side, it also creates a forum for the business to understand what the family's intentions are. For those businesses, I mean, there are many instances family are actively involved in the business, but there may be a lot of non-family members involved in the company as well. And it does create more of a professional structure whereby family is able to articulate to the non-family management team what their intentions are. By the same token, it also incorporates the mission, vision, and strategy of the family, and then how that dovetails with the business. And then lastly, in the business context, it also assists the business and the family to groom future talent. So that's whether it be succession planning for the future leader or different positions within the business. So, I mean, there may be family members that have an interest in wanting to fulfill different roles in the organization, and this structure, or the family business structure, creates that forum. Next slide, please. As Pia finished off on her last slide, leaving a legacy of love. The one aspect, and I've having had discussions with Ricardo in the past, regarding adopting a collaborative planning approach, it really is an encouragement where family owners are in a position or prepared to be open once having had the conversation with their wealth advisor, to then embark on a conversation that involves the family members to understand what their intentions are with respect to the wealth. So on a collaborative planning approach, it really is not only involving the individuals that have created the wealth, but at the same time being able to have open communication and conversations with family members so that they have a clear understanding of what is the intention for the perpetuation of the legacy. And what that does is, on the second point, it creates a healthy culture of shared attitudes, values, goals, and behaviors, so that all family members know what the intentions are for the perpetuation of the family. Then the last point being is the development of the next generation. I had an interesting conversation with a client yesterday, and it's a large farming operation where this family have, I think it's now a third generation business, a husband and wife, and there are 3 siblings that have established a very large farming business. And the conversation was along the lines of their 3 children, and the father was the person that was articulating a lot to me, and I was trying to ascertain, had there been some establishment of his successor. And in the conversation, I think it made him realize that he is at a stage that he would like to start focusing a lot more and in the selection of either the suitable CEO or in the organization, as well as the development of other individuals and family members. And I indicated to him, it's really attesting to him with the fact that he'd taken the initiative at this stage, while he's still actively involved in the business, to be articulating the development of the next generation in the business. Next slide, please. In the concept of family business governance, there's one element which is the ability to have open family meetings. And I mean, it's interesting. I think, you know, in family businesses, a lot of families run or conduct it in a very informal style, and it's a wonderful way of being able to communicate matters. But at the same time, there is the importance of being able to have formalized family meetings where, in particularly when it comes to estate planning, and a lot of what we've been discussing is the management or the accumulation of wealth in a trust, and having an open communication between the parents and the heirs to be able to discuss what the intentions are with respect to the trust, and whether it be who the trustees are. I think most hope the heirs know who the trustees are, but at the same time is that being able to have an open communication, that they understand the details in a great more, you know, detail. It also affords the opportunity for the heirs to ask some questions, you know, and express their feelings just when discussing the estate planning. Doesn't necessarily mean they have the opportunity to vote and say, well, they're not in complete agreement with the parents, but at least it does afford the family members to have an open communication. Again, when I had the conversation with this family yesterday, I asked, had there been any formal family meetings? And the father said, no, I've had individual conversations with my son or daughter, and from their response, they intimated, and I could understand what their intentions were, but it was clearly apparent that there hadn't been a structure whereby there was an open type of forum where the family members were able to have open dialogue and resolution. Then the last aspect of having this at an early process, well, initiating this early process and open communication, is that it enables there to be really wise decisions on how to treat the children and how to ensure that it's not, you know, like a smoke and mirrors situation where the owners or the wealth that's been accumulated, that there isn't open dialogue that takes place. There's also opportunity for training the children and to enable them to have a clear understanding of the privilege of the stewardship of wealth. It also allows the children and parents to express their feelings and to have open communication. You know, in many instances, I think for any parent, the last thing they would want to see happening is that there's going to be a dispute between their children when they're no longer alive. And I think that by having this type of communication at an early enough stage, definitely enables, well, in many instances, that dialogue assists in enabling that potential conflict to be reduced. And then also the last thing is it enables the parents just to articulate to their children in a great detail, well, some detail, how they would like their plans and their legacy to be perpetuated to future generations. I think this, in summary, provides you an overview. I mean, I know there's been a large amount of content that has been covered over the last 2 sessions, and I think there's a lot to absorb. And I guess, you know, by going through this process, I think there's been a lot of food for thought, and I know that Ricardo is going to possibly open up to some questions.
Trevor, thank you, and thank you, Fia. Thank you both of you for your insights and shared wisdom. I think, like you said, there's a lot to consider in marrying family with the trust. But I think the golden thread here, in both conversations we've had, is it's all about conversation, and even more conversation. It's just really getting the family speaking, clarifying wishes and their vision, and then planning for the future. And all of that really comes together in what is central to be in having a well-administered trust for that family legacy. So thank you, Fia and Trevor, for sharing your perspectives and valuable insights. I am reminded, before we go to the Q&A, though, Trevor, of a client experience that you shared with me recently, where you had first-hand experience of how divorce proceedings really highlighted the poor administration of the family trust. Trevor, won't you please share the lesson that you took away from this particular client experience?
Yes, thank you, Ricardo. Yeah, Ricardo, when we had the conversation, I mentioned to you, I mean, I recently prepared an article about the preparation of both a well-prepared anti-nuptial agreement and the important, although in the article it doesn't go into a great deal of detail about the trust. When dealing with this particular client, which is from a wealthy family, the benefit that this client had when I had the conversation with the client about the divorce that they're in the midst of, the client fortunately has an anti-nuptial accrual agreement, but at the same time, one of the things that was extremely beneficial to this client, when I asked the question about the trust, the trust administration, I asked them, you know, had you had meetings? Were there meetings of the trustees? Are there resolutions that have been prepared, etc.? Pleasingly, the client was able to convey to me that this was the case. I think, you know, I know in the next session that's going to be taking place is going to be about the administration of the trust. I think I'm sure fear comes across it very often. People say they've got a trust, that they've got the trust document, they put it into a file, and then they neglect to manage that trust or administer the trust properly. And they actually undertake transactions without proper resolutions. And there's transactions that take place over a period of time, which eventually does create a situation that the trust is ultimately possibly their alter ego, or it's a sham trust. And that was, you know, when I was advising this client, I was able to say, well, I'm pleased that you have administered your trust professionally.
Sure. Thank you, Trevor, for sharing that. I think that really, marries that topic that we're talking about today, is that it's not only what's in the deed or how you administer your trust. That's critical. But it's actually bringing in the anti-nuptial contract. It's bringing in all the other aspects of family governance into the conversation and making sure that they're aligned. It's no good having the trust deed in conflict with the ANC or the trust deed in conflict with the family council or wishes. And I think that's a very powerful message. So thank you for sharing that, Trevor. So let's have a look at let's continue the conversation with our audience. We have received 3 questions so far. Fia, if I can ask you to, if I can direct this to you. Deerwald, thank you for your question. Deerwald asks, when a discretionary trust ends or it's terminated or vested, and trustees do not distribute assets equally, so I'm assuming do not completely distribute the trust, what does that mean for beneficiaries? Who can claim the balance of the trust assets? Yeah.
A couple of things are important to remember. I think your starting point is your trust deed. What does your trust deed determine? What must happen upon dissolution of the trust? But just remember, although most trust deeds have discretionary power, so the trustees can actually divide the assets in the ratios they wish, the courts have also found that that does not mean that trustees can do whatever they wish. The starting point is beneficiaries have to be treated equally. So if you want to favor one beneficiary over another, you're going to have to demonstrate that you have applied your mind and that there is a very good reason for kind of deteriorating from that kind of a starting point. But I think the first place to go and look is your trust deed. Does it stipulate anything? Because often the trust deeds have any termination clauses. What must happen with the trust upon termination? If it does not have that, you would start off with beneficiaries have to be treated equally, and if there's deviation, you need to motivate that.
Okay, so really there can't be a beneficiary making that election.
No, absolutely not.
Thank you for clarifying that, Fia. Another question for you, Fia, from Peter Hughes. The question he's posed is: a trust can be sued and can sue, not so? So he says, if so, why then is it not a legal entity?
No, a trust can't be sued and can't sue.
Okay.
It is the trustees in their capacity as trustees on behalf of the trust that would sue or would be sued. So the trust is not, and that's why a trust is not a legal entity. It cannot, stand on its own feet in our law, unless certain legislation, do define them as persons. For example, the Income Tax Act speaks as a trust as a person, so it is treated as a separate entity. So it may have legal personality, but it is not a legal entity separate from its owners.
Right. Thank you, Fia, for clarifying that. And then a final question, which I think I'd like to pose to both of you, Fia and Trevor. I think it's evident that there's a real distinction between being a trustee and a director of a company. I mean, the roles are unique and independent, but yet often families fall into the trap of having the same trustees as directors on family businesses. Trevor, let's start with you. What is your best practice in terms of that decision? How do you deal with it?
Connie, my impression, I don't think that there's a problem with having both a director, being a director of a company as well as being a trustee of a trust. The importance of both aspects, a trust should have independent trustees. So ultimately, in order to ensure that the trust is administered professionally, the trustees should have at least one or two independent trustees that are either non-family members, and ideally a firm or somebody that is actually a professional trust administrator. If that takes place and the trust is professionally managed, I don't foresee there's an issue by having both being a person being a director of a company and also being a trustee of a trust.
Okay, thank you, Trevor. Fia, your view?
What is interesting to remember is if you act as a director of a company, you're acting in your personal capacity. So again, for which you can be held personally liable. When we look at the trust holding companies, it's important to remember and understand, other shareholders. If the trust is 100% shareholder, the directors and the companies, the directors and the trustees have to be in alignment because they are acting for the same shareholder and the same set of beneficiaries. So, and there's a lot of court cases where people have been blocked to say that, you've got nothing to do with the trust, you're just a beneficiary of the trust. And what's happening in the company is too far down. So the courts go right down. So you must remember, as a director, you just can't do as you wish. You have to act in the best interest of the shareholder, being the trust. And in the trust, the beneficiaries are the beneficial owners. So I think that's very important to understand, when you act, but be very careful when you act as a director, you do so in your personal capacity.
Lovely. No, thank you, Fia and Trevor. Again, I think not cut and dry, but I think the awareness of the implications of those decisions. Fia, a question for you from Jacques Sherman. Would you recommend using a comprehensive and specific letter of wishes authored by the founder and directed to the trustees to give guidance to the trustees?
I think it's a very useful document, especially when we do this whole kind of family constitution, what fits in where, with the will, with the trust, whatever's in the trust, what, do I intend, happening to the trust. It just gives further guidance. You can certainly not prescribe in terms of what has to happen. And especially when you've got minors in there, to which schools they must go to how they must be looked after. So those things are important, which I think, a letter of wishes does have a place. Be mindful, it can't override a trust, it can't instruct trustees what to do.
Okay, lovely. Thank you, Fia. And then a final question. I know we're slightly over time, but I'll take the last question. Trevor, for you, if you can close on this one. This is from Monica. Her question is there a framework available for family governance and the trust deed?
An interesting question. There isn't specifically a framework in place that connects the two. A family governance structure is an iterative process. So it depends on to what level of professionalism that the family would want to embark on. The importance is to do it in a staged approach. So it would be really just to have, you know, a family meeting, and then ultimately at a later stage preparing the constitution. But at the same time, there isn't a one structure that fits all. You know, it's each particular family has their own peculiarities. So there isn't just a template that would suffice across all family businesses.
Perfect. Thank you, Trevor, for clarifying that. Well, thank you everyone for joining today's conversation. The webinar has been recorded, and a link to the recording will be made available on the BDO Wealth website and BDO YouTube channel. And any additional questions we receive will be answered and addressed directly. Our final episode in this year's Talking Trust series will be hosted on 6th July at 11 a.m. And there we're dealing with trust accounting is not trust administration. That's right. Valid and well-administered trust is so much more than simply compiling the annual financial statements. There are many misconceptions and much misinformation about trusts and the trustee's responsibility for administration. So please do join Fia and I as we unpack the myths and realities of trust administration and how to ensure that the trust is not at risk of being attacked as an alter ego or sham trust. So until then, if you have any questions relating to the administration of trust, please do reach out to BDO Wealth Advisors, and we'll be glad to help you get to the right solutions. Stay well, stay safe, till we connect again. Goodbye.